Virginia has been a focus of the campaign for the fair sentencing of youth for nearly a decade. Following the U.S. Supreme Court's decision in Graham versus Florida, striking down life without parole sentences for children convicted of non-homicide crimes in 2010, the CFSY joined Virginia State Senator Marsden to advocate for legislation abolishing life without parole for children in the Commonwealth. We offered our expertise on the legal landscape, national context, and brain science, and Senator Marsden brought to the table a dogged dedication to reform Virginia's youth sentencing laws and to address the Commonwealth's failure to comply with U.S. Supreme Court precedent.
Virginia has been a really tough state to work in historically. When we went in and tried to assist Senator Marsden with a bill that would have brought relief to kids who had Graham sentences. And so Graham, was a case that came down in 2010. And so Virginia still hadn't complied with the Supreme Court's ruling in Graham.
Following the decision in Miller versus Alabama in 2012, which struck down life without parole sentences for the vast majority of children, we at the campaign took the lead in recruiting pro bono counsel for all those in Virginia who were eligible for relief. Our legal team recruited an incredible group of pro bono attorneys to represent Virginians serving JLWOP, including Josh Toll, who now serves as the CFSY's board chair. Josh represents David Sanchez, who was sentenced to life without parole for a crime he committed in 1998 when he was just 17 years old.
As we reviewed the file, David's potential really jumped off the page. We could tell that he was deserving of a second chance, and we know that our society's criminal justice system is often too harsh. We faced many roadblocks while representing David in the Virginia courts. First, initially, the court found that Miller was not retroactive. Thankfully, Montgomery was decided, and we received new life on the retroactivity point, and our case was remanded. But even beyond that, we faced the prosecutor's office and seemed unwilling to consider that our client really did deserve a second chance. Instead, they seemed repeatedly to rely on technical defenses, and we had to litigate whether mandatory truly was mandatory in Virginia. But through it all, we persisted, and we were helped by the fact that we really do have an incredible client, and his family is amazing too.
Virginia had, for a long time, been trying to circumvent the U.S. Supreme Court's decision in Miller v. Alabama, and they did so in very nefarious ways by interpreting their statutes in ways that nobody had ever interpreted them before, by saying that we weren't impacted because we didn't have a mandatory life without parole sentence. At the same time that was happening, the efforts in the legislatures were stymied in part by a handful of policymakers who really were against Miller. And we ran up against that same sort of resistance for many years. And Senator Marsden, to his credit, every year thereafter, kept introducing his bills.
The United States Supreme Court in multiple cases has ruled that juveniles must be treated differently from adults when it comes to being sentenced to life without parole.
Throughout this time, the pro bono attorneys and families of those serving JLWOP in Virginia have been steadfast in their advocacy. Two family members, Maria D. and Jana White, joined forces to create a coalition dedicated to ending life without parole for children in Virginia.
I started this journey because of my cousin Stephen. He is a juvenile lifer who was sentenced to life without parole at the age of 16. And he is now actually eligible for parole, so he has life with parole. I actually met Maria D. in a visitation room at the prison. I was visiting my cousin Stephen, and Maria was visiting her loved one, David Sanchez. So we met up in the visitation room, and we connected afterwards, and we joined forces because at the time there really wasn't a voice for Virginia juvenile lifers. So she had founded the Virginia Coalition for the Fair Sentencing of Youth, and I just jumped right in and pretty much kind of just took over. And we worked with the campaign, and it just kind of became what it is today.
The family members really were the heart and soul of the work in Virginia. And, I'll never forget some of the very difficult conversations we had to have with them, Virginia being one of the first states that the campaign really engaged in fully. And yet, we were unable to bring any sort of relief to them and their loved one. And, I think a lot of the staff, myself included, lived with that that notion, and it bothered us a great deal. And so Heather Renwick and I actually, and Nicola Nabel-Juris sat down with the family members at some point, had this conversation, and also talked to them about engaging in an advocacy campaign on their own. They organized themselves, they organized advocacy days, they went down to the state capitol, and they did this year after year. This was very much an effort that was grassroots, that was driven by the family members who just refused to give in to despair, to give in to the hopelessness of the situation that they were facing, given the political realities in Virginia at that time. And they just continued to fight like hell.
The campaign for the fair sentencing of youth has provided Maria and I with a level of understanding and a level of material to where we could go to our legislators and say, look at this study, look at this state, look at what they're doing, look at the U.S. Supreme Court and their rulings. And the campaign has provided us with everything that we've needed to be able to go to our senators, our legislators, and go into the Senate and House and say, look, other states are doing this. Our children should not be sentenced to die in prison. They are far more than the worst mistake they've ever made. And the campaign has been the backbone of that.
Mr. Malvo's counsel worked tirelessly on his behalf, and we at the CFSY partnered with Malvo's legal team to implement a careful yet robust media strategy. The CFSY also built relationships with some of Malvo's survivors, who eventually filed a supportive brief in the U.S. Supreme Court and served as public spokespeople around the oral argument, advocating for a second chance for all children, even children like Malvo, who commit the most serious crimes.
It's simply about giving kids the opportunity to demonstrate that they're more than their worst act.
James is on point. He knows his stuff, and he took time to come to Virginia, speak on our behalf, and really push for our bill to be passed. And we are forever grateful to James Dold and the time that he spent just working with us and helping us and being there at the Capitol to make a difference.
Seeing none, the question is, shall House Bill 35 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote?
After nearly a decade of advocacy in the Virginia courts and at the legislature, in February of this year, Governor Northam signed into law the bill that effectively bans JLWOP and gives parole eligibility to all children tried as adults after no more than 20 years. More than 700 people currently in prison will be eligible for relief under this new law, and all children tried in adult court in the future will benefit from the protections of this bill.
What was accomplished in Virginia this year was really the culmination of, a years-long advocacy effort that really centered around the people who were most directly impacted and directly harmed by these sorts of reforms, and for them keeping faith and never losing hope that things could change.
In light of the new law, the Virginia Attorney General and Lee Malvo's counsel filed a joint motion at the U.S. Supreme Court to dismiss the case. Yet we know this isn't the end of the fight, but rather the beginning of the next phase of work. The CFSY, along with family members and dedicated pro bono attorneys, are now working to ensure that parole is a meaningful process for the hundreds of individuals impacted by this reform. And as a community, we must step up and support those who are released with employment, housing, and opportunities for a meaningful life outside of prison. Our work is not complete until individuals condemned to die in prison as children are home and thriving in our communities.